This is set for a status conference. Ms. Wogen, do you have counsel?
Yes, Your
Yes, I do.
Honor. Attorney Warren Wall, P78662 for Ms. Wogen.
I do see that now, Mr. Wall. Thank you very much. How do you wish to proceed today, Mr. Wall?
Your Honor, it's my understanding that my client will plead guilty to an added count 2 disturbing the peace, MCL 750.170. The original count 1 will be dismissed.
That is a correct statement, Your Honor.
And that's a 93-day, $500 misdemeanor?
It is a
That's
90-day misdemeanor.
90 day. All
Correct,
right.
Your
Is that a $100 fine?
Oh, I'll have to look that up.
We'll just
Give me a
say
second.
5 in case it's a little bit more than the 100, but I think it's 100. All right,
It's 500 actually, Judge.
at 500, great. Thank you very much. All right. Ms. Wogen, you've heard what the lawyers and I have said. Is that what you want to do?
Yes, Your Honor.
If you take advantage of that plea offer, you'd be giving up your right to have a trial and all of the things that would happen at a trial. Do you understand that?
I do, Your Honor.
Let me explain those to you in a little more detail so you can make an informed decision. You have the right to have a trial in front of a judge or a jury. You have the right to be represented by an attorney at that trial. At trial, you could see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence, or to get a subpoena from the court to require your witnesses to appear and testify. You could testify yourself if you wanted to at trial, or you could remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, I do, Your Honor.
Do you have any questions about any of those rights?
No, I do not, Your Honor.
Knowing all of that, do you still wish to enter a plea today?
Yes, I do, Your Honor.
I'm going to take some testimony from you. Would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, go ahead and put your hand down, please. Has anybody promised you anything other than this plea agreement to get you to plead today?
No, Your Honor.
Has anybody threatened you in any way to get you to plead today?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right, the amended charge of disturbing the peace would read as follows. It would say that on or about February the 17th of 2026 in Livingston Township of Otsego County, that you did disturb the peace and quiet of the people around you at that date and time. Is that what happened?
Yes, Your Honor.
Could you tell me how you did that?
My husband and I got into an altercation and the police were called and I was arrested.
Was that a loud or boisterous or altercation which caused the neighbors or people around you to have their peace and quiet disturbed?
Yes, Your Honor.
All right. Either counsel have any additional factual basis questions?
I do not.
None, Your Honor.
Either counsel aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
No, Your Honor.
Do both counsel believe I've complied with the plea taking court rule?
Yes, Your Honor.
I do, Your Honor.
All right. I will accept the plea. I believe it was given to me knowingly, intelligently, and voluntarily based on the statements made by in answer to my questions. Ms. Wogen has indicated that she disturbed the peace by getting into a disagreement with her husband on the date and time and place noted in the complaint. Therefore, I will accept the plea. I believe she's given her a waiver of her proper rights as well.
In Your Honor, the victim is here today and also did a victim impact, so I would leave it at the court's discretion, but
That's correct, Judge. Mr. Wogen's here. We forwarded his victim impact statement to both the court and Mr. Wall. So I would just have the court inquire of him whether there's anything else he wants to inform the court of.
All right, give me just a minute. It was presented to me earlier this morning and I have not had a chance to review it. And then I'll give Mr. Wogen an opportunity to say anything that he wants to in just a minute. All right, I've had a chance to review the victim impact statement of Ryan Wogen. Mr. Wogen, is there anything else that you want to say at this time, sir?
There is, Your Honor. And I respect the court's decision on how to proceed here. I don't have any opinion on sentencing or the reduction in charges, but I did want to add that, I've been with Amanda for 16 years. I was never fearful for my personal safety prior to this incident, nor do I now. And I don't think that she's a threat to me in any way. She's a loving mother, a good friend, a good daughter, an empathetic and talented nurse, and a contributing member to this community. I think she was backed into a corner, figuratively speaking, that morning, but I believe the incident was isolated, and I do see mostly good in her, because I guess love doesn't die overnight. As far as our communication with one another, we've been unable to communicate with one another at all, and we have 3 young children that we're trying to define a new normal for, and not being able to speak to one another, not being able to, having to tell the kids that mom and dad can't speak to one another because they'll get in trouble is anything but normal. And for the sake of trying to develop amicability and to provide some sort of normalcy for our kids, I believe Amanda wants this, but she'd have to answer that. We need to have full communication with one another in order to be able to try to get our kids out of this that was forced upon them at a moment's notice in the wrong way. And the only request I would have, per her divorce attorney, she has the intention to get back into the family home to do co-parenting. I don't think that would be a good thing. But as far as the bond conditions that were in place before, I think they should all be lifted, with the exception for being able to get into the family home until she has permanent accommodations.
So help me understand the current circumstances that you and she are in. Is there a divorce pending?
There is a divorce pending, yes. And, legally speaking, we both have full custody of the kids, but because she doesn't have a suitable living situation, the kids are living with me and are seeing her periodically.
All right. Your written impact statement was that you didn't want her to be inside your home until after June 11th. And is that you continue that request?
I do, with the hope that she can find permanent accommodations, and also, the fact that, we have our oldest birthday party that weekend. And if we can remain amicable, and if she finds suitable housing, then perhaps we could be together for his sake on that following day.
All right. Is there anything else that you want me to be aware of, sir?
The only other thing I'd say is that the morning after the incident, she got back into the family home, and she took a significant amount of cash and the kids' birth certificates and social security cards. Her boyfriend lives in New Jersey. So I don't know if this is a matter of divorce proceedings, but I don't think she should be allowed to leave the state of Michigan for the time being.
All right. Thank you, sir. Ms. Bruker, your comments?
I really don't have anything additional. I think Mr. Wogen covered a lot of ground with his impact statement, his comments.
All right. Thank you. Mr. Wall, allocution.
Thank you, Your Honor. In this incident, there were no injuries. Miss Wogen has no criminal history. This was a very isolated incident. As heard, they are going through a divorce. As stated by Mr. Wogen, he is not currently afraid of her. My only concern about the out date of the home to that June 16th date is I think it's using the criminal court to establish a custodial environment outside Miss Wogen in the divorce case. I think she's a hardworking person. She is a loving mom, and she has went above and beyond to make sure she's obeying the court order. She would not do any phone calls. She would not even use third-party communication to talk about the children until the court approved that, which is correct. She was very adamant about that. Mr. Wogen has called her numerous times. She has always ignored those calls due to the court order, even though it breaks her heart not to see or be able to talk to her kids more. She definitely does want to be a large part of their life, as she is the main caregiver to the kids. But again, the only thing that I would counter is I would hate to see the criminal court be used to establish a custodial environment in the divorce case. I'll leave it up to the court's discretion, Your Honor.
All right, thank you, Mr. Wall. Ms. Wogen, you have the right to address the court prior to sentencing as well. Is there anything that you want to say?
I just want to say I take this situation very seriously, and this incident was isolated and doesn't reflect who I am or who I've lived my life. I deeply regret everything that happened.
All right. What, if any, counseling have you received, ma'am?
I have been doing weekly online therapy counseling with a family marriage counselor, and I'm prepared to do any other type of counseling that you recommend.
What do you believe to be the underlying reason for the incident that occurred? I mean, I get it that there's a relationship problem or may have been, but what was, in your mind, what was the impetus of this case?
My marriage has been breaking down, but my husband found out about an online relationship that I was having, and that caused the fight that night.
Is there anything in addition to what you've done so far, the family counseling, that needs to be addressed so that you don't have to go through a similar situation in the future?
I do currently have appropriate housing. I'm living apart from my husband currently. And so I believe that we are both committed to being great co-parents to our children, and believe that was a one-time lapse of judgment that will never occur again.
No substance abuse issues that may have contributed to this?
I do not, Your Honor.
No mental health conditions that may have contributed to this?
I do not, Your Honor.
Is there, other than family counseling or the counseling that you're currently doing, is there anything else that you think would be of assistance to you in any way in preventing this in the future?
I do not, Your Honor.
All right. Where do you currently work at, ma'am?
At Siegel Memorial Hospital. I'm a registered nurse.
How long have you had that role?
12 years.
All right. That is a role with a lot of responsibilities. It's a serious role. So I'm going to trust that you understand the serious nature of these circumstances, not only for yourself, but for your children. Anytime that there's a breakdown in the relationship between a mom and a dad, the kids are the ones that end up suffering the most. So the best job that you can do is to, and that's why I ask all these questions of you, the best job that you can do is fix you if anything needs to be fixed. I get it that relationships sometimes break down, but that doesn't mean that the relationship that you have with your children needs to break down, or that it needs to end up as in a problem. The two of you can still co-parent at a high level, and I expect that you will do that and put aside whatever issues the two of you have and accomplish that. However, having said all that, today is not about family and divorce issues. It's about criminal matters. The only reason I'm addressing it is I don't want to have left any stone unturned in asking you to fix whatever needs to be fixed so that you can not have this problem occur in the future. All right. And I believe that you understand what I'm saying, so I'll stop preaching and get on with doing the sentencing. So having said all that, I am going to put you on probation for a period of 6 months. There is a crime victim fee of $75, a justice assessment of $50, court costs of $200, fine of $100, and a local charge of $15. The 6 months on probation costs $180 for a probation oversight fee. I'll total that up for you. A total of $620, and you can pay that over probation. You may perform some community service in lieu of those fines and costs at the discretion of the probation department. I am going to, as a matter of probation, require you to attend family or personal counseling and follow all recommendations. That means do whatever your counselor says for as long as your counselor says, in whatever manner your counselor says. If he says you're done tomorrow, that's fine with me. I don't think he is, but if he does, you just follow what he says or she says, whatever it is, and you'll be fine with that. You may need to sign a release so that the probation department can communicate with that counselor and vice versa. And once that counselor says that you are done with whatever counseling you need to do, some information needs to be transmitted from that counselor to the probation department so that we can confirm that you've accomplished what you're supposed to accomplish. As a part of the criminal case, I am not going to make any rulings as to when and how and under what circumstances you can have contact with your kids. That's a family law issue. I am going to indicate that you may have contact with Mr. Wogen. It does not appear to me that he has any ongoing issues with you, and I think he's looking for and working towards being able to communicate with you. He certainly has the ability to say, you can't come to my house, and under what circumstances you could in the future come to his house. But from my perspective, the two of you, I believe, are adults and can make that determination on your own. He's certainly able, if he wishes, to say, you can't come to my house, and then the family court can say, what are the circumstances under which you can have contact with the children? That's for the family court to decide, so I'm not going to do that. Once the probation order goes into effect, the bond conditions will be released, and so you would not be under that no contact provision anymore at that time. I'm just going to make a note of that. There will be no assaultive, abusive, intimidating, or threatening behavior while you're on probation. You are to maintain employment while you're on probation. And I am going to require 20 hours of community service work for two reasons. One, I believe that you need to give something back to the community for what you took by doing the criminal action that you did. And secondly, I want you to feel as if you have accomplished something. You've done something good for yourself. And I think community service work, anytime that you give back to others, it helps you personally as well. So for both of those reasons, I'm going to require 20 hours of community service work. Any questions that you have, ma'am?
No, Your Honor.
Mr. Wall, any questions?
Would she qualify for the 3-month termination if she's completed
Yes,
everything?
that's a standard condition of probation. After you successfully complete at least half the time of your probation and all of the conditions of your probation, you can ask the court for permission to be released
I'm not
early.
sure if it qualifies for early release.
Based on the crime?
Yeah.
I will look into that, Your Honor, and get back to my client on that.
Ms. Hill, if I say it does it?
I'm not sure.
That's a loaded question. Mr. Hill, Mr. Wall, for your benefit, I'm indicating on the sentence form that it is okay to release early if she qualifies. And so if you do the research, I'd appreciate it.
I will, Your Honor.
Thank you very much. That's all for today.
Thank you, Your Honor.
Thank you, Your Honor.